the last one to someone else. We're going to give her. All right, so welcome. Finally, we're having a statute review subcommittee meeting. As y'all know, we have rescheduled this. This is the third time that we've had to reschedule it because we did not have a quorum. But thankfully, we do have a quorum today. And I appreciate y'all for being here. And I understand why y'all weren't here before because I can't always be here. We all have very, very busy schedules, but it's, it's important work that we're trying to do. And maybe in the future, we will do what we did last time. Instead of just picking a date, we'll send out kind of a survey with 2 or 3 dates and then try to make sure that at least 8 people commit before we schedule it. So maybe that'll work better. So before we go any further, LaTonna, why don't you go ahead and review the meeting rules for members on how we will conduct business virtually, including that recording of the meeting will be posted on the Commission's YouTube channel.
Yes, thank you, Judd. And good afternoon, everyone. I am LaTonna Lawrence, and I'm the Program Coordinator for the Georgia Child Support Commission. And I will briefly discuss a few rules to help us navigate the meeting today via Zoom webinar. The Statute Review Subcommittee members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other panelists are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. The Child Support Commission does not hear the Statute Review Subcommittee does not hear public comment during any of its subcommittee meetings. Accordingly, we will not be accepting public comments today. However, you may leave a written comment for the Commission at any time during the Commission's website, which I will post in the chat momentarily. Also, anyone wishing to give public comment by speaking may do so at any full Child Support Commission meeting. And the next one will take place on March 21st, 2025.
She said their motion.
In conclusions of today's meeting, staff will post the recording on our YouTube channel, Georgia Child Support Commission. And I will place that channel in the chat for everyone momentarily as well. Thank you, and I'll turn it back over to Judge Wilford.
All right, well, we have a very lengthy agenda today, and I have some notes here of some things that I'm going to cover, some things that Katie's going to cover, our co-chair, and some things that Noelle is going to cover because she has done a lot of research and can speak more intelligently on some of these things than maybe Katie or I could. So we're going to get through as much of this as we can. If we don't get through the entire agenda, we may have to push some things because it is a lengthy agenda. I think the reason for it is because we worked so hard on the parenting time adjustment, the low income adjustment, some of the things that we're trying to get passed in the legislative session that we kept sort of putting some of these other things off that were important things, but we just, had to pick our battles, as my mother would say. And so we're going to start trying to address some of these things that we've been putting off. One of the things that we want to start by doing is just talk about the status of the revisions to 19.615. General discussion regarding any feedback that anybody's received pertaining to the changes that were brought forth by Senate Bill 454 and any sort of cleanup that may be needed. Sometimes when we pass a big bill in the legislature, I say when the legislators pass a big bill in the legislature, we need to have some cleanup work maybe the next session. So if any statutory changes are needed, then we, can work on those. I know my notes suggest, I haven't talked to Regina personally about this, but that Regina Quick may have mentioned to Noelle a few months ago that she thought the consistent addition of the word adjusted and the term parents combined adjusted gross income and similar references to adjusted gross income could be confused with the tax term adjusted gross income, so that perhaps the commission should consider undoing that change that was included in SB 454. And unless someone else has heard of any additional feedback, that's the only one that I had noted. But I'd like any and all SB 454 comments or feedback that anyone wants to discuss that we start out by discussing that now, just sort of a general discussion. So any feedback, any concerns, any cleanup that anybody wants to discuss before we talk about Regina's suggestion? No? Well, I'll just tell you, I'm hearing very positive things. Katie and I did an award-winning, if y'all haven't seen it, it's going to be Oscar-nominated video that is on the website. And I have been approached by many attorneys, I'm pleased to say, in the Middle Georgia area. I've even had a couple come up to me in restaurants and say, I watched your video and I'm using it. I'm using the calendar and I'm using the tool, and and I said to one of them, well, I hope it made sense and I hope it was easy to use. And she said, it made perfect sense to me, but of course I'm very familiar with child support. So, I said, well, we weren't going to do a whole basic child support video. There's plenty of those on there, but we assume that people are generally familiar with the child support worksheets before they watch our video. But yeah, I've heard nothing but positives. I had one attorney who told me, yeah, it's a little more work, but it's necessary and it was needed. I've received a couple of emails from attorneys who said, this has needed to happen for so long and we're so glad to see it. And it's so helpful and it's so useful to now have a tool and a formula that we can use, or that we can at least argue on what the parenting time deviation should be until it becomes an adjustment. So I've heard absolutely nothing but great feedback. Sarah says, I got a lot of great feedback from legal aids, family law attorneys about the changes as well. Lots of praise for your video. Thank you, Sarah. So I'm pumped. That's very exciting. All right, so Regina was concerned about the term adjusted gross income, and I hate to sound ignorant, but we've always had the term adjusted gross income in the statute, right? Are we just using it
Judge,
more than
can
we
you hear
used
me
to?
okay?
Yes.
So that was a discussion that we had during the SB 454 moved through the legislature, and I don't think we need to waste any time today discussing that comment. It was just a going through the statute question as we went through it, as we were going through the legislative process. So I've heard nothing but positive things as well.
Well, thank you, Regina. If you make a comment to Noelle's Johnny on the spot. She's not going to forget it. So just be cautious about that.
Well, that was a comment that is in the category of Thanksgiving leftovers. So it was
Okay.
leftover from session.
If there's something major wrong, this is my opinion and only my opinion, and I'm just one person in this big important group, but unless there's something majorly wrong, I don't want to open that can of worms. Like, it was so hard to get this thing where we got it, and I was so pleased with it. And I have heard nightmare stories of coming back in to tweak one little thing in a bill, and all of a sudden the whole thing gets undone and gets, reopened and gets rediscussed and gets torn apart. So unless that's something that's a big issue for you, I say and it sounds like it's not, I say we just let that one ride.
Judge, I agree. And the statute, the law change, that's a change in circumstance, is a much more important discussion from my perspective.
Okay. All right. Well, if no one else has any comment on that, then I'm going to turn it over to Katie. She's got some things to discuss about drafting some clarifying language under 19615. And I won't steal her thunder. Katie, what did you want to discuss?
Thank you, Judge Williford. So we discussed it at the Child Support Commission meeting 2 weeks ago. Like Judge Williford just said, and Regina and Sarah, I've been hearing nothing but positive feedback about about the changes and the updates to the statute, and, you know, sort of long overdue. I mean, it's occasional grumbling about having to learn a new, you know, piece of it, but mostly conceptually certainly positive, and everybody's just working on getting their head around it. And I won't even say however, I'll say, and I've had a handful of judges and practitioners, actually, interestingly, mostly judges, but practitioners too, ask me the clarifying question that will the parenting time adjustment, you know, moving from a deviation to an adjustment, where it was not taken into account at all for an existing child support order, will that constitute a substantial change warranting a modification in and of itself? And we know our current guidelines already provide certain scenarios in which you're allowed to modify, and then even some built-in, you know, where you can't modify once you've done that, you know, within certain windows. I know I'm preaching to the choir here, but I've been asked. I will share with you that my opinion is that even as it is written, modifications would be appropriate. But I have some concern that without an express statement that, you know, that it does constitute potentially, by the way, it's never, you know, modification is never guaranteed. But that having, you know, accounting for the economic impact of parenting time, if it was not previously accounted for, should justify, you know, get you through that initial threshold of change warranting a modification. Then, of course, it's up to the court and the parties and the then current circumstances, income, expenses, you know, et cetera, all the things that we put into every child support calculation. But so my question for the commission was, should we ask the legislature to clarify and make an express statement about that?
And while I was not at that meeting because I was in a horrible trial, my understanding is that they asked you to draft some clarifying language for that. And tell me how it ended, what y'all ended up doing at that meeting regarding that issue.
So we talked about drafting some proposed language and maybe circulating it via email through the commission, but it just stayed on this agenda because it was on our agenda from before that meeting would have taken place.
Okay.
So
it sounds like y'all have already dealt with that.
Commission seemed open to it. I'm just putting it before this body to say, you know, we would have discussed it otherwise.
I mean, I will just say what I just said, which is opening that can of worms scares the bejesus out of me. But if y'all have already discussed it with the entire commission, then just draft it, send it out, and let's see what becomes of it.
Okay.
Any comments regarding that? Any further? All right. Next, we're going to move to discussing removing the 7% test. Y'all may have forgotten about this, but it's something we discussed, and then we kept talking about it and then forgetting about it and putting it off. But the 7% test and the deviation for special expenses for child rearing, this is something that we see, and I know there was a case, and I know Noelle's going to brief us on it. There's been at least one case, or not more, that kind of discussed how we messed this up. But when I was a practicing family law attorney, I know I saw frequently people would put, you know, you're going to split child, you know, extracurricular 50-50 or whatever, you know, and it didn't take into consideration that, all right, there's already 7% of the child support amount being paid towards that. And is it beyond that? And so there was a question about whether or not that was just going to be removed altogether. And I think Noelle has a brief primer on this topic. Noelle, let's talk about that.
Sure. Thanks, Judge. So this comes up in the deviation for child rearing expenses. And let me back up. 7% of the BCSU table is meant to account for what Dr. Jane Venora calls entertainment. She says it's more than just extracurriculars, but it does cover extracurriculars. So the deviation currently says that the deviation amount can only be for the expense that exceeds 7% of the BCSO, and the calculator's programmed to do this. it's complicated. It can be complicated to explain to folks, but
You've lost me
basically-
already. You've lost me already.
all right, I'm sorry.
Let's break it down in real layman's terms. So
Mhm.
the 7% test then is not just these special expenses for child rearing. It's entertainment, period.
No, so when you're, I'm sorry, so when you're requesting a deviation for special expenses for child rearing, the statute and therefore the calculator makes you test whether those expenses exceed 7% of the BCSO. And if they do, then it's only that portion that exceeds 7% of the BCSO that gets split up between the parents to pay. So the deviation amount exempts 7% right off the bat and then lets you deviate. Now, Dr.
But like
Bernard-
taking your kids bowling or to the movies or whatever could potentially be a special expense for child rearing?
No, but those expenses, bowling and movies or whatever, is part of the 7% in the BCSO. It's not just extracurriculars. I think there was some confusion there, maybe.
Maybe another folklore.
Right, exactly. So years ago, like if we decide today, then I think we're going to pursue this. I think it's probably a longer conversation than just today, and we may even want to invite some folks to speak with us in the future, including possibly Dr. Van. There's a staff attorney out of Chatham County. He has called me, and we've had a huge discussion about this. But so basically, what's happening is a couple of years ago, several years ago at this point, when this first popped up, we asked Dr. Vernor about it, and she reiterated that it's only us in Tennessee that does this at all. And I think that's likely because we just mimicked a lot of our statute mimicked Tennessee. It was used as a template to start with. So I'm not sure anybody could officially explain where this idea came from. And also, she says it's down to 6%. So, so there's that. So Mary,
I'm already encouraged that it needs to go, but I agree that it needs more discussion.
Yeah, I think Dr. Vernor would do a better job explaining this, but this is also wrapped up with a topic that doesn't seem like it would be necessarily related, but it is, and that's handling the extracurriculars outside of the child support worksheet. So there's nothing expressly in the statute that this can be done, but there is something in the statute that it can be done for work-related childcare. So I think that's interesting.
And I can speak to that, Noelle, when you're finished.
Sure. Well, let me just go through this. I have some slides developed that I thought I'd talk through. So we have at odds, what I see is OCGA 19615 C6, which is the provision that allows the parties to come to an agreement contrary to the presumptive amount of child support, or the presumptive amount. But then also the special expenses for child rearing with the 7% test in it. A few years ago, back in 2020, there's a Court of Appeals case, Day versus Mason, that made it clear that when a party does this, like pulls extracurriculars out and agrees to say, for instance, in this, in Day versus Mason, the court ordered the non-custodial parent, who was the father, to pay half of the child's future extracurricular activities with a limit of 1 activity per season. And the parties agreed to this. And it's my understanding that this is regularly done. It's general practice, certainly in Metro Atlanta. Yes, everybody's shaking their heads. But the Court of Appeals rejected the agreement and rejected the order, saying there was no factual findings to support a deviation. So they found this agreement to be a deviation from the presumptive amount of child support, which I think is was sort of an interesting take on it, because Katie in particular, you may remember when we were first talking about this years ago with the study committee, we were saying, what would this be? And could this possibly be a non-modifiable term, et cetera, et cetera. But it's kind of streamlined it, because now the Court of Appeals has made it clear these agreements pulling something out of the worksheet is seen as a deviation. So I think that's helpful. But they rejected it, saying there were no findings of fact to support such a deviation. Okay. Since then, there's been Wiggins versus Rogers. It's also out of the Court of Appeals in 2023. Very similar situation. The non-custodial father was ordered by the trial court to pay half of the child's extracurricular expenses, and without making the necessary findings of fact to justify a deviation. But then what's muddied the water or made things even more complicated, it said, if the trial court is going to deviate, it must consider the 7% requirement of the deviation called special expenses for child rearing. So that it was rejecting it not only for findings of fact, but for not figuring out what 7% of the BCSO, like an across the board, we're just going to split 50 things 50-50 or per our pro rata shares going forward. The parents would have to figure out what 7% of that was and then divide that expense. So we have at odds sort of the statute and that section of the statute that says the parties can make an agreement. So I think they can make an agreement, but I don't know. Anyway, now I'll toss it over to Katie or whoever else wants to speak about this.
Katie, you said you could speak on it.
Just a little bit on the work-related childcare. That was a post January 1st of 07 change, being allowed to take that out. When it passed initially, our income shares model, it did not allow for work-related childcare to be taken out of the worksheets, if you will. I'm going to use that phrase because I think everyone on this Zoom anyway understands what that means. That was not allowed, and we were getting a lot of pushback because, in particular, the really compelling argument was that very young children who were before school age, that's an incredible expense related to children, is that preschool work-related childcare. There's no such thing generally as public preschool. And so when we were building it into the worksheets as required by the code, then we were having much bigger child support numbers because parents were paying for preschool for a 0 to 5-year-old ish, and that as soon as the kids were starting kindergarten, even if there was aftercare and things like that necessary, the expense on a monthly or weekly basis dropped significantly. But the parents were required to go and file a modification to address that, even in cases where you had a 3.5-year-old or a 4-year-old where you could see the light at the end of the tunnel for that to end. So we went in, and I think I was just pulling it up. I think we made it, skimming through the statute. We talked about pulling it out and being within a certain time period at the same, but I could be mixing that up with I am. Okay, so at the same time, we also addressed the issue where you have multiple children and they are old enough. So now on the other end of the child support timeline, where a child aging out, graduating from high school or otherwise emancipating is also kind of around the corner. And we're having, there was no mechanism to address that, where you were going from 2 or more children to, 1 less or 2 less as they were aging out. And so we amended the statute, through the commission, this committee and then the commission, and then with the help of the legislature to allow for that. I think that's where we have the 2-year rule. If you've got a child, emancipating within 2 years, you can go ahead and calculate, what it will be for the remaining child or children. And then work-related childcare, again, we said it could be taken out. As I recall, and I may not be the best person to speak on this, although maybe Mr. Cuthbert might remember this. I think he was around at the time. I think the concern about the work-related childcare was from child support services because, and people who needed what, of course, we were calling income deduction orders. Now we're calling them something else. But you couldn't collect on those additional, and X% of. And so that was the pushback was, if you say child support is X dollars per month and you know, 62% of work-related childcare, when they went to enforce that through child support services, they needed an exact number in the order. So that's why it was written in a way that allowed the court to include it or not, because there are plenty of people who wanted it out but didn't have the option. And then there was also a sector of the Georgia population who needed it to be in just for collection purposes with child support services. So that's the history of that. I will say, as a family law practitioner in, Metro Atlanta primarily, although I do have cases in the four corners of Georgia, and everywhere in between, I think this is a issue worth addressing. And I don't love the way that the appellate court has interpreted it, especially as it relates to parties agreeing, because much like work-related childcare, where a child's going to age out, or even when, you have a 16-and-a-half-year-old child and a 14-year-old child, and want to go ahead and account for what's going to happen, 17 months from now when the first one ages out, I think you're limiting parents' ability to go ahead and be proactive and not have continued, strife and litigation, and, what they can very easily anticipate is around the corner. And I think extracurricular activities similarly they're a variable. They change. A child that can't get enough of one sport right now, or even let's go the other way, a really, really young child might not really have, appreciable expenses related to extracurricular activities, but they're going to, why force a modification? Not to say the parents can't bring a modification if they meet the other criteria, change of income or any of those things, but I wish it weren't just based on the fact that it's time for, dance or soccer or t-ball. So those are my 2 cents.
Comments from anyone else? Concerns, questions?
I'll say that I think it's definitely something worth taking a look at, from the standpoint where I see it with practitioners and mediation. Majority of people do it outside the worksheet.
Mm-hmm.
Probably, if I had to put a percent on it, it's probably like 98%. It's a very high. So it's been something that's been done for a long time. For some people, it's just easier. It keeps them having to, file for modification, going back, kind of flooding the courts with more cases. So I think it's definitely something worth taking a look at, because I think for most people, that's how they're interpreting it anyway.
Well, and I clearly was doing it wrong, probably was, but when I was practicing, I would figure out what 7% was and say, all right, well, if T-ball cost $100 a month and 7% of that is, $7, then, he's already paying $7, the difference is $93, then we're going to split that. I would try to do the math and figure it out, thinking, well, 7% is already built in, and kind of do it from there. But then there would be a paragraph in the settlement agreement that said, and in the child support addendum that said, this is the way we're dealing with the extracurriculars. So I didn't put findings of fact necessarily, but, so it's interesting that this has come up, but I will say that in reviewing documents all the time now in the last 4 years as a judge, I frequently see extracurriculars included with no mention of the 7% or anything like that. And so it seems like, based on these Georgia Court of Appeals cases, that we do need to address that. And perhaps it would be nice to hear from Dr. Venor to see. I mean, I'd hate to run into a whole big thing with a big bill like we did on some of the other things, but just this one issue, kind of how are most states dealing with this? How is it usually addressed? And I don't know, Kurt, what the process is to find out from Dr. Venor how much she would charge us to do something like that, and what we would need to put together. And I guess would we present that to the entire commission for approval, that we needed to hire Dr. Venor to educate us on this 7% test issue, or what do y'all suggest?
I'd say, based upon Based upon, well, based upon the in-depthness that we're going to ask on it, I mean, she's been pretty good about like giving, just her kind of general opinion on nationwide issues, but it kind of just depends on the depth we want to go with it.
Yeah. I mean, if it's only us in Tennessee that's doing it, and it's not even 7% anymore in Tennessee, it's 6%, that speaks volumes to me. I mean, if that's true, I have no reason to believe it's not true if that's what Noel's been told. But it's kind of like only us in Mississippi have this legitimation statute. That's a huge red flag to me, So I feel like I feel like my gut is like it needs to go. Well, once it goes, then what? Does that mean we need to address it some other way in the BCSO? Does that mean it just goes and then from now on practitioners deal with extracurriculars outside of the worksheets, period? And what does that really encompass? Because you're saying, well, it's special expenses for child rearing. It's not extracurriculars. And that includes entertainment. So that's mind blowing to me because I'm like, well, what all does that's vague. What all does that mean? So I do have some questions for Dr. Venor that I feel like needs to be answered. And if we're going to do away with it, we're just go, all right, we're doing away with the 7% test. Well, then do we need something in its place? You know what I'm saying? It's like, all right, so how do we deal with these things now? Or maybe it's just not part of child support, period. And you deal with it by addressing it, which leads me back to the legitimation. I'm going to call it legitimation problem in Georgia, because if almost 50% of children are born out of wedlock in Georgia or something close to it, and a lot of those folks are going through the department, then they don't necessarily have a divorce decree or something like that a settlement agreement that's going to govern this entertainment or these special expenses for child rearing, and so you're going to be left with, 45, 50% or whatever the percentage is of Georgia's children who don't have this added, expense built in for the special expenses for child rearing if we do without it. So it feels like if we're not going to have a 7% test, there ought to be something to replace it so that those children are not without this, this additional support, this additional 7%. So what I would like to do is just walk away with this, with the idea that Kurt, you and or Noel are going to figure out what is the process, if you don't know already, to see how we would get Dr. Venor to attend our next, if not our next, statute review subcommittee meeting, and kind of answer some questions for us on this particular topic.
And I would just add to that, Judge Williford, just looking down our agenda, I think we may find when we get a little further down and talk about the high income deviation, we might like for Dr. Venor to opine about that as well. To me, those are two issues that I get questions about very regularly. I understand it's a small percentage of the population, which I tell people also very regularly, but it's not an insignificant percentage, at least of the metro area. And I think those are two areas where a little bit of opining from Dr. Venor might give us some direction. Maybe not, but it might at least give us an idea as a subcommittee how we'd like to tackle the issues.
Well, since we have all these additional little small issues that we kept putting off that are on our agenda, as we move through it, we may say, well, that's something else we could talk to Dr. Venor about, Again, I don't want, I don't know how much we paid Dr. Venor last time. I know it was not insignificant. So I don't want to, I don't want to spend a whole lot of money on this, but I think it's important that we at least see what it would take to help to get her to address these issues. And maybe if she attended a meeting and knew more about what we wanted her to do, then she could give us a better estimate. All right, so we'll move on from that with the idea that we're going to look further into that. It is an important topic that we need to keep at the top of our radar and get some, it sounds like, some expert advice on. When modification may be brought within a 2-year period under 19.615K. This is something that Noel also gave us a primer on at some meeting, maybe our last meeting. Maybe I'll have her give it again, but it seems like it came up, Noel, if I'm remembering this correctly. Unfortunately, I don't have the statute memorized like y'all do, but isn't this one of those things where it's like you can bring it within a 2-year period only under these very limited circumstances? And one of them seemed to be something like the non-custodial parent is not exercising the parenting time, is exercising more or less, I guess, I don't know, parenting time than what was initially thought of. And I said, well, isn't that ironic, since parenting time is really not a part of the equation? And somebody said something like, well, maybe that was just left over from when it was supposed to be, and then the legislator scrapped Schedule C and we didn't take that out. And then somebody else said, no, that's if there was a parenting time deviation that was awarded under Schedule E. And in fact, even though you were given this parenting time deviation, upwards or downwards, whatever it was, you weren't actually exercising it, then you could come in, even though it was within the 2 years, and ask for modification. And I said, well, it doesn't seem clear to me, but maybe, you know, is that what we're talking about, Noel?
Yeah, there was some confusion, I think, between, we're really citing the statute down in the weeds now. It's like I2K, which is the parenting time deviation, which is now completely struck, well, soon to be completely struck in about a year, with just the general provision on modification, which, as you were saying, allows modification within 2 years. If there's been a failure to exercise the parenting time, or the converse of that, the non-custodial is actually exercising a great amount of parenting time than was originally thought about.
The question now is, if we actually are doing away with that period, right? It won't exist. Are we going to have a new provision that says, hey, now that we have a parenting time adjustment, if you're not exercising, if you're exercising more or less, are you going to be able to go in and ask for a modification within that 2-year period? Or have you got to wait until they don't exercise their parenting time for 2 whole years before you can modify it? Is that the question now?
Yeah, so now I think it's resolved itself, because the deviation isn't quite struck, but that's only a year away. And the modification statute, or the modification subsection, allows for a modification within 2 years if it's either direction. The parties aren't doing the parenting plan, non-custodial either has them less or more. And if there's significant, we know going forward, if there's a significant change in that because of the parenting time adjustment, then we would want modification sooner than 2 years, because that can really, if somebody said it was going to be 50-50 and then it's nowhere close to that, they're getting a substantial adjustment and it's not warranted. So I think this may have naturally resolved itself on its own, unless anybody disagrees with me.
It sounds like it did. I am concerned that somebody might come in and file a modification because dad didn't exercise his 2 weeks this month, or his, missed a week in the summer. I mean, it seems like it ought to be, or mom, I shouldn't say dad. I hope we're not going to be bombarded with filing modifications the first month that somebody misses a weekend. You know what I'm saying? Is that what you're saying, is that now that we've basically done away with it, at least effective as soon as the adjustment takes place, that the modification language is going to allow it to be brought within that 2-year period anyway, if they don't exercise their court-ordered parenting time?
That's my
But
understanding.
it doesn't have a time limit at all. It just says if they don't, then you can modify it.
Right. It says no petition to modify child support may be filed by either parent within a 2-year period from the date of the final order on a previous petition to modify by the same parent, except when, and the first is the non-custodial parent has failed to exercise the court-ordered parenting time. And then the next is the non-custodial parent has exercised a greater amount of parenting time than was ordered.
And, you know, I guess we'll just have to see how it plays out, but the concern is really now that the adjustment is actually meaning dollars in a real sense. You
I
know,
agree with you, Judge Williford. I think your concern is valid, but let me say, we could make the same argument about somebody getting a raise, you know, after child support is set. And we've had that conversation, and, you know, and yeah, they could say, I want to, you know, I think his or her income has gone up or down, and I want to, and, you know, we haven't seen, I mean, I'm not saying we don't see some people abuse that, but I think it does have a little bit of self-governance in that, you know, I don't think people file it because you got an extra, you know, because you got a $10,000 bonus this year, or, you know, I mean, so I think, I don't know, you could make the same argument about changes in income is what I'm saying. And I think,
what is the
different.
changes in income language in that statute, Noelle?
I think that's what would constitute a substantial change in circumstance. You would need to make sure that would be the initial bar first.
Yeah.
It says, unless there is a substantial change in either parent's income and financial status or the needs of the child. So I take that to mean a substantial change in income, not just, like Katie was mentioning, a tiny
Yeah.
raise that's not going to change.
But is that different than the language on the parenting time? Because the substantial language is not in the parenting time part, right?
That's right. The
Right.
word substantial is not in the parenting time part.
Yeah. I think that's the difference.
Right.
But if they go in and calculate and say, okay, you know, he or she has not been exercising or has done more, what would my child support be if I accounted for what the parenting time has really been versus what was court ordered? Because that's really what we're talking about, is what's the reality versus the court order. You know, sometimes that number is going to make a substantial difference in the monthly amount, and sometimes it's going to be a negligible amount.
Well, a couple days
Right.
here and there doesn't really,
Move the needle.
as y'all well know, it doesn't impact it that much. It has to be, we're talking like 50 days or something per year for it to really start moving the needle, so.
Right. And I guess that's what I'm saying.
Maybe we just won't borrow trouble until we see that it is an issue. And maybe down the road, if it becomes an issue, we look at whether or not we need to add substantial language or something like that to it.
Yeah.
Any
No, I agree.
comments, questions, concerns about the modification, when a modification may be brought within a 2-year period? All right, hearing none, then we're going to move on. The next item on the agenda has to do with the terminology for non-custodial parents and custodial parents. And as everyone probably recalls, we had a poll online last year. That poll did not lean towards any changes. I think the overwhelming numbers, Noelle, wasn't it, was that we would keep the same terms, and that there was some concerns that it may possibly be the result of a large DCSS participation. I think DCSS was keen on keeping the terminology the same, but Noelle, what say you in terms of, are we giving up on the non-custodial parent and custodial parent terminology, or where are we on that?
I think it's something to throw open to the committee, where the subcommittee stands on that.
Mhm.
But that's what happened. I mean, we do get asked about it. I have a note in here. I think some training events for mediators, it was discussed. I think when you're in that setting, there's more sensitivity about it because you're calling somebody custodial. And I mean, they really are misnomers. It's conflating, somebody's child support obligation with how much custody they have, and that's just no longer the case. We have to call them one thing or the other, and people who have upwards of true 50-50 are somehow called the non-custodial. But the poll did show that most folks in Georgia, or the ones who answered the poll, said to just leave it. So it's whether or not the subcommittee wants to pursue it.
I was a little bit shocked by the poll results because I have always found the terminology a bit offensive, but there's not a real good solution to it. I think we threw out several options and there was arguments to be made why it didn't work one way or the other for each one of the options, or why it might be confusing, especially when you pull the statutes and look at things about the custody statutes and those sorts of things, and the terminology didn't match. So but let me hear from y'all.
Do we know, Noel, what came in second place in terms of the terminology outside of non-custodial? I don't remember.
I am sorry to say I am not sure. I'd have to go back and look at the poll results.
Okay, gotcha.
But after non-custodial and custodial, we jumped to more financial terms, things like
payer.
I think it might have been payer, payee.
It wasn't really even payor and payee, I don't think. It was more
payer and receiver was an
yeah,
option.
maybe something like that. We tried to make it real layman's terms, and I don't have the results in front of me, and I wish I did, but I do know that it was a substantial difference. It was like, if you looked at the graph chart, it was like this many wanted to keep it the same, and then the next runner up was like way down here, and so Byron or Regina or somebody just had folks online just plugging away at that survey. Didn't you, Byron? Why are you laughing? So, I don't know. It just, now, the folks that I personally discussed it with, like fellow judges or fellow practitioners, they're like, oh, leave it alone, just because people hate change. So I think that might have been a component of it too. It's just like, there's so many changes and just leave it alone, because people have a hard time with change,
Yeah, I was surprised too that it didn't come out differently, actually.
So I was also surprised it didn't come out differently. And I feel like we got a lot of public comment from people who are interested in not using language that, even if it's not intended to marginalize, it does marginalize. But I also understand change is no fun. I will say, I think if we picked different words, we might not have such a issue with the flip scenario. I'm using air quotes here, that we're all, because then it wouldn't be a matter of flip. It would be a matter of, how does the formula, like, what does the formula tell us about child support? And then it's not a matter of labeling someone custodial, non-custodial, and then having to say, oh, but we're flipping. It would, the end result.
Custodial parents having to pay child support,
Right, exactly. So maybe that would eliminate, our already acknowledged flip problem.
Well, I just want to interject on that, because of the flip, which is shorthand for when the custodial parent would pay child support to the non-custodial, largely attributed to the new parenting time adjustments. We did have to add a term to be able to adequately explain that. We added payer, the payer, to the statute, so that we're working on what the new work will look like once we adopt, once the 2026 amendments come online. But at the bottom, like right now, it's just unclear. In fact, I have folks ask me all the time, like, parents who just call her on our trainings. They're like, well, what does this mean? They think you net out the 2 columns. And it's really not clear. So there's room for improvement on our worksheet, but there'll be some sort of explanation like, XYZ is the payer and will pay X amount to, it'll be clear going forward. But we had to add that because non-custodial and custodial are terms in the statute that are defined primarily based on amount of parenting time and secondarily based on income. You can't just say they flip. You can't just say, you said it and this is the definition. And then if it turns out that the custodial has to pay some child support, the non-custodial, then you somehow call them the other words. It just gets way too messy. So that's why payer was added. So this also may work itself out a bit as we work through the new worksheet. Because
you have your hand up.
Yes, thank you. Yeah, to Noel's point, we do plan to have an additional line at the very end of the calculator that shows up in big bold letters saying that John Smith is to pay Jane Doe, $565 a month, or if the parenting time flips it, Jane Doe's to pay John Smith, $100 a month or something that may be. But I did want to say I did find the results of that survey. And the next 2 options were the next runner-up, if you will, was primary parent and secondary parent, for what it's worth. Payee, payor was very low. Greater parent time, lesser parent time, that was very low. And the second place was around 1,100 votes, and then first place was around 3,600 votes. So it wasn't even remotely close. So
Do you have percentages there?
Don't want to have to do the math on it.
No, that's okay. I just thought it was on the chart. Okay, so yeah, so primary parent and secondary parent was the second runner-up, then with 1,100 votes.
Correct.
And I used to call it, when I was a practitioner, I used to call it primary custody and secondary custody in all of my parenting plans and settlement agreements and that sort of thing. But then, of course, you got to the child support worksheets and it had to be custodial or non-custodial. So I don't know. I mean, we asked for the poll, we did the poll, we put a lot of work in the poll. And so part of me is like, well, then why did you do it if you were just going to ignore it? But then part of me is like, really, if we're talking about 5,000 or 6,000 votes out of the millions of citizens of Georgia, is that even an accurate by any stretch of the imagination for statisticians? Would they say that results of that poll had any validity whatsoever? I think they would say no, absolutely not, because of the small results and but I don't know. I'm just I can see both sides. I can see we've got all these changes and people are getting used to these changes and we've made some progress, and let's not just keep on stirring the pot and making more changes. And I can also see, like, words are important, and while we're making these changes, let's just make them so everybody can get used to all of it, so I can see it all the way around. I guess I don't have really strong opinion one way or the other, but if I had to vote, my preference would be that we need to change the terminology. But what do y'all want to do with this issue? I mean, how do we handle it from here forward? Are we going to,
I think my opinion is we kind of put it to the back burner, that we sort of push it back. I think the other issues with the 7%, the deviation, as well as the expenses for child rearing, probably would be more precedent, more important in my opinion right now. versus that. But it is important. I think at some point it does need to be discussed, despite the poll. I agree with you. I think it's not a good sample, not even close. But I think right now, and maybe, like Noel is saying, it'll work out with some of the changes that are already coming. It might not be as big of an issue, but perhaps to revisit it.
And I think when we asked for as I recall, when we asked for a list of what other states were doing, and Katie or Noel, one of y'all sent out like a chart, and it was surprising how many states still use the custodial and non-custodial. It was a lot, as I recall, the majority.
Right. So we're not an outlier in this particular
Right.
thing. This is something where, even if it's problematic, we are in the mainstream of what language other states are using.
Yeah. All right. Well, let's move on from that then and go to new business. Katie?
All right, so first on our new business list is the, let's see, is there a reason that 19.615 carves out an exception for filing of worksheets in cases for protective orders? And we're looking at 19.615 subsection C1 and M1, excuse me, and I'm calling on Noel to discuss that further, please.
And this is something I had just thought about a while ago, and we never got around to it. I just want to say that I'm fine dropping it, really. But where my thinking is that it's clear in the statute that the guidelines apply in all cases involving child support, including, and it expressly says, it cites the temporary protective order statute, the TPO statute. But then in the very back, the statute at M1, flip there for just a second, it exempts you from filing a worksheet with the TPO. So I just thought that was interesting. And I was just thinking, how in the world would you set child support using the guidelines and then not do a worksheet? But it might be more than we need to delve in.
I have never seen, and I'll just tell you my personal experience as a practitioner and now as a Superior Court judge for 4 years. I have never seen child support in the Macon Judicial Circuit, Macon, Bibb, Peach, or Crawford addressed in a TPO.
Mm-hmm.
I see it addressed in TPOs in DeKalb and used to see it in Cobb fairly often. It's by no means universal.
Mm-hmm.
But particularly in TPOs with married parties or where dad is already legitimated and parentage isn't really at issue. I've seen it provided for. What I will say is that I see it happening in TPOs in a much more sort of ad hoc way, where if it's ordered sort of based on whatever documentation they can produce that day without formal discovery and so on. And so I can see where it is inconsistent, but I can see where in those instances it's sort of more of a placeholder. And they're doing the more elaborate child support worksheet and discovery process in a child support proceeding or a divorce or legitimation or whatnot.
Yeah.
And that's where this is Pat, that's where the supplemental orders that many counties are requiring originated, was in the TPO cases. So I think that gave them more of a background of this is what the income is, and this is how many kids it's for. And so that gave the court some information on how much time the parents were spending with the children and that kind of thing in that emergency situation. They're using it all the time now for every case, but that's how it started out.
Pat,
Let's see, I'm just not familiar. I'm not familiar. Where are the supplemental orders coming from, Pat?
are you referring to the addendum?
Addendum, sorry, yep.
Oh, I have wondered where in the heck addendum came from. I can't tell you how many judges I've said that is not required, but they won't, a lot of times they won't enter a final judgment decree without it. I'm like,
Right.
You're just.
And it depends, it's county by county.
Right.
What addendum are y'all talking about?
So a lot of the metro counties, a lot of them require what they call a child support addendum.
Yeah, we don't since day one, we have not had a divorce with children where you don't have a separate child support addendum. So in the Macon Judicial Circuit, you have to have a separate parenting plan and you have to have a separate child support addendum. And some folks will send us like a settlement agreement where they've kind of cut and pasted the child support language into the settlement agreement. And we're like, where's your child support addendum? And they're like, huh? So
Yeah, it's like where
yeah, I
they
guess
build in,
every circuit's different, I guess.
it's where they build in all the statutory language, but in DeKalb as well. They
Yeah.
have to have a separate. If anything, I've seen DeKalb be more willing to occasionally accept a parenting plan incorporated into an order when you have like a sole custody situation where it's very, very straightforward. But I've always had to do an addendum if child support's an issue.
Yeah, a child support addendum with the attached child support worksheets is required in our circuit. But you're saying that child support addendums, Pat, are being filed in TPO cases? Is that what you're saying?
I'm saying that's how the addendum came to be. It was intended to be used at TPO hearings originally.
Oh, so you'd have a document that included the statutory child support language that isn't in a TPO 12-month order?
Right.
That makes sense, I guess.
makes sense.
I didn't know that was its origin, but I could see that.
Well, that wasn't well understood, I don't think, based on my experience practicing in probably half of the counties in Georgia. The child support addendums are used in any case involving child support if they're used. But again, both in my experience as an attorney where I practiced in dozens of counties and as a judge in 3 counties, I won't say I've never seen child support in a TPO, but I can tell you that I could probably count it on 2 hands. They're usually told to either go to child support services or they file something separate, a divorce or, petition for child support or something, that the court handles, outside of the TPO. And, it has caused me some concern because obviously when you look at the forms for the TPO, there's a whole paragraph about child support and about custody and about visitation and all that stuff, but we just never address it. We don't address it. It's just too much, I think, to address.
It's been a matter that we've briefed and such in DeKalb in some cases because, since the statute does provide for it as relief available in a TPO, in some cases where we've been representing parties where for whatever reason it was very important that it get established.
Yeah.
So I could see that it's very county to county, and within DeKalb, it's even varies a little bit judge to judge.
Yeah.
But the statute's clear that it's available as relief. So
Yeah, and certainly I've had folks argue it from legal services. I've had folks argue it from the crisis line here, but
yeah, for our clients in poverty, it's sometimes just a real concern. And sometimes people do sort of thread that needle by ordering a respondent and a TPO to do something like continuing to pay a mortgage or to pay daycare expenses or something in lieu of child support as a short-term measure. But, there are some judges who refuse. There are some judges who do it. We've been looking for cases on which to appeal it just because if it's in the statute and it's as a policy never actually granted, legal services use that as a problem.
yeah, I can see why. So the question.
I'm going to have to hop off. I'm sorry. I'm going to have to hop off the call in a moment to pick up my children. If there are any matters that you all need me to chime in for, feel free to, I don't know, if someone send me an email quickly. I'll be around. I just need to get my kids. So.
All right. Thank you, Sarah. I'm glad you.
Of course. Have a good afternoon. Bye.
All right. Was there anything else, Noelle, on that subject then about carving out an exception to filing worksheets in cases for protective orders? So you're saying that is in there now, that it carves out an exception, and should it not be in there? Is that your question?
Yeah, and I'd rather just not upset the apple cart at this point. If no practitioners think this is the problem, then I don't think we need to make it a problem. I just thought it was interesting. It says it applies, but then it says you don't have to file a worksheet with the order, which doesn't really make sense to me because I don't know how you apply the guidelines and not use the calculator. But
Well, I think my 2 cents is this. People are in usually sort of a desperate and emergency situation when they need a protective order.
Right.
And trying to figure out, if we have proof of their income and their tax returns and their last 2 paycheck stubs and who works where and are they self-employed, and nobody has time for that. You're trying to say, don't come within 100 yards, don't go to their school, don't go to their work, don't call them, don't text them, don't email them. And great, it sounds like if you have the information, then yeah, you can address it. But I'm going to say that 9 times out of 10, you don't. And so I think it's important that that exception be in there and that it not be required. That's my 2 cents.
I agree completely.
Yeah,
All right.
I agree. I'm changing my mind. I'm done. That's done.
All right, Katie, move on to the next new business, please.
Next new business is the high income deviation, which I brought up a minute ago, but Noelle, do you want to speak to that?
Yeah, sure. I agree. I get questions a lot about it from practitioners. Also, I feel like it's the number one thing a judge will stop and pick up the phone and call me about. I did talk to Dr. Venora about it relatively recently, but she said that there really isn't, like, I was wondering if there was any more guidance. It just says give a deviation. And so judges are like, how do I come up with what a deviation amount should be? So I talked them through the process and how I think about it. But she said there isn't any good formula or any good, I don't know, she didn't have much advice on that. But I think it's something we could, if we're going to ask her to speak, we could raise that with her and put her on the spot and ask directly, not through me. But she didn't have any good suggestions right off the bat.
It sounds like she said that's not something that she sees commonplace nationally, and that there isn't currently any formula in any state that she's aware of that that she favors, or that that anybody's using for situations like that. It's sort of just a discretion thing, right?
Right. I do remember her saying there's no formula nationally. I'm not sure where she stood on whether there's the high income deviation in general. I just don't recall at this moment. But I do know she said there's currently no sort of formula or a standard on how states handle it.
I think that's interesting because I don't have many of those cases before me, but in a situation where somebody does make, several $1 million a year, it's like, how do you come up with the child support amount for that? You read these cases out in California where these, superstars, and, you all of a sudden, somebody's getting, I don't know what I read, something crazy. Holly Berry's ex-husband is getting, $100,000 a month or something, and a percentage of her income over 2 million or something. I was like, what? But how do you come up with that?
Yeah, right. Just like it's wide open right now. And so, for instance, it was interesting, and it's not just in Metro. Somebody called me from Glynn County, or the case was in Glynn County. They're in the Atlantic circuit down there. And I said the first step in deciding whether the deviation, any deviation is even needed is, do you think the child is being adequately supported, given the totality of the circumstance, the presumptive amount of child support, and then whether you already granted any deviations? Are you accounting for like a private school or some, I don't know. So that's the first step. It's also very complicated.
I guess the question is, if, is the child entitled to live in the standard of living to which he or she has grown accustomed, because whether or not a child's adequately supported is very vague.
Yeah, I will say, folks think what definitely should not be done is if somebody, soon to be 40,000, right? Because our BCSO table now caps out at 40,000. If somebody makes $50,000 a month, or let's say $70,000 a month, you don't find out you've got the presumptive amount based on 40,000. You then don't go and figure out how much it is, say that's $70,000 a month. You don't figure out the differential being 30. You jump to the amount for $30,000 and then combine those two together. That's definitely not economically sound, but some people think that's what you do. But it's because the rate of child support doesn't stay the same. Like the change between, somebody earning $29,000 a month and $30,000 a month, it goes up ever so slightly. So I don't know if there's more education to be done about it, or
I speak on this a lot. I touch on this in almost all of my trainings because I get asked about it, and I'm speaking to the audience of, of practitioners usually, and what I usually end up saying is something like, look, I cannot give you guidance from an economic perspective that is supported by our underlying economic theory. And the reason for that is it's very expensive, and it's not linear. So you can't just take our child support and draw the line out. And then I say, think of it this way, how much it costs, 2 school teachers to raise their 2 children, even in Metro Atlanta, how much they spend on their children is different than what 2 lawyers, I usually point to myself because my husband and I are both lawyers, it's different than what 2 lawyers spend on their children. But you know what we spend on our children is very different from what, say, Jay-Z and Beyonce spend on their children. But it's not like you would say to Beyonce, hey, congratulations on that additional contract you just signed. Blue Ivy standing there with her hand out looking for her X percentage of that. That's not how it works. I mean, do more people who make more money spend more on, do people who make more money spend more on their children? Yes, but it's actually a diminishing percentage usually more than it is an increasing percentage, and I just tell them there's just no way I can't give them an economic basis for it. But I get asked a lot about doing the difference. All right, well, I did the math, and I've had judges say it to me. Well, I went ahead and ran the child support up to the max that I could, and then I took the amount they made over it, and I ran a new child support worksheet. I'm like, no. But then again, it's a deviation. So if that just makes the judge feel better, as long as they do the findings of fact, I'm not sure I don't think they'd necessarily get overturned on appeal. But if they're looking for an economic basis consistent with our entire scheme, it doesn't exist that I know of.
Well, when we get Dr. Venor on here, we'll ask her, but it sounds like based on the conversation Noelle's already had with her that she's not going to have an answer for us. I don't understand, if she told Noelle that the last time she talked to her, I don't think she's going to tell us something different. So what do you suggest we do then, Katie?
I think there's a good chunk of the family law bar that is clamoring for an answer. So I think maybe we ask Dr. Venor just that, what would you say to them? What would it look like if they wanted guidance? I mean, maybe she's going to say nothing. I will give you nothing because there is nothing, but maybe she'll say, well, I don't know, this, that, and the other. I think to this point, people sometimes just back into the math because they're, I will say, having just reread it during this meeting, the special expenses of child rearing language in our current code section could be a place to address even high income situations because those children are going to have more expenses, because not every family can afford to put their kids in, I don't know, horseback riding or whatever, and, sleepaway camps versus day camps and, things that, that do show, that they're spending more on their children. So maybe we encourage people to, utilize that. First, we take care of the 7% thing. Then we encourage them to utilize the, that section of the existing guidelines, because there's certainly language in there that contemplates if your kid is doing more and there's expense associated with it, there is a way to account for it.
And isn't that the way it's being accounted for in reality? Is attorneys and mediators and judges are saying, all right, you're also going to pay for the private school tuition. You're also going to pay for the horseback riding. You're also going to pay 100% of the medical expenses. You're also going to pay for the child's
Auto
first
insurance.
car and the car
right.
insurance and the
Mhm.
cell phone and the sleepaway camp and because you're rich and because you have all this money, we're going to make you do all these other things, buy, the X a house and, all these things, right?
Mhm.
Kurt,
I mean,
your hands up.
I was just gonna say that, I mean, yeah, that was an email conversation we had with Jane Venora. I can follow up with her and at least see what states are doing it, to at least give us some kind of, map to crack into their statute and take a look at it and see, which way they're kind of doing it. She did say she didn't like any of the formulas that are being used out there, but there are a few states doing it, so I can at least follow up and at least find out something.
Okay.
And I don't know what Christina sees in mediation because she does that all day, every day. But I will tell you, I talk to my clients, whether I'm talking to the payor or the recipient, about when they're at the really high income levels. I talk to them. I say, let's focus less on a high income deviation and more on child support plus, plus, plus. That's what I call it. I said, we're going to do plus the car, plus the auto insurance, plus the cell phone, plus. So I call it
Plus
child
the
support.
college, plus the private
Right.
school, plus the,
Right.
yep.
So I call it
Right.
child support plus, plus, plus. And I said, let's focus less on that high income deviation that's going to come in the monthly chunk. And let's get some of those direct expenses that your child's going to incur covered by the high earning spouse or high earning parent.
Yeah, exactly. That's mostly how it's handled. Absolutely. Make them pay for all the other stuff if they have the resources. I have seen it with a few clients where they will put a number as I guess I call the old line 51, the non-specific deviation, and put a number there to make it upward. But for the most part, it's usually the expenses or the other things that are important. And that's what I guess my concern with trying to do a formula, if it's going to, because I understand like you said, there's a percentage that wants it, they need some guidance, but I'm wondering if they're not gonna be happy with however it comes out. Because I think having the flexibility with that is of benefit sometimes, especially in mediation when you're negotiating.
Yeah, because if there's a formula, they're gonna say, no, this formula says I gotta pay. I'm not paying a penny more.
Yep.
That's right. That's true.
Yeah,
They do think of the formula as a cap.
Mm-hmm.
correct.
And what you all are saying is what I try to convey, especially to judges, that when I said the totality of the circumstances, like, is a high income deviation really warranted if they're getting the presumptive amount and they're, and all of those pluses, as Katie was calling them, are already, then you don't necessarily need to order then a high income just because they exceed the table.
And the
So-
good thing about that, when you do it outside of the child support worksheet, is sometimes it's hard to modify that. Whereas if it's child support, it's easier to modify. All right, well, let's move on from that. We will see, Kurt, what you can find out about the formulas that are being used. I know that Dr. Venor may have said there's not any that she favors, but what are they? How are other states, if anyone, handling this issue? The next thing I see on the agenda is just a question. Is there a need to further define attending secondary school? And I'm glad that this was put on there, whoever decided to put it on there. I have never had a client who didn't confuse secondary school. Never. They think it's college.
Yep.
Just call it what it is. High school. Secondary school is high school. Primary school is elementary school, right? I mean, why do we call it secondary school?
I don't know.
Agreed. This came out of when we were looking at the statute last year. This was added to one of our kind of wish list items or back burner items, like on a list that we had of things we can look at in the future. Agreed, 100%, Judge. Secondary school should be referred to as high school. But another big question that's kind of that I've seen, at least, my time with DCSS, that I saw some was, what constitutes attending a secondary school, though? Does it need to be full time? Does it need, can it be online? If it's online, does it need to be in pursuit of a high school diploma? If it needs to be in pursuit of a high school diploma, can it be in pursuit of a GED certificate? And these are things that kind of DCSS has wrestled with. I can tell you their specific policy as it is written right now is that secondary school or education is defined as the pursuit and attainment of a high school diploma. Their policy goes
Full-time,
on.
right? Full-time pursuit, right?
It does not say full-time. It does say that GED testing services offers any adult who want the opportunity to earn a high school equivalency, but they do not consider GED to be enrolled in secondary school. So if they're in pursuit of a GED certificate, that doesn't count. But if they're attending online school, it does, but it doesn't necessarily have to be full-time. So, even if the statute was amended, and obviously it's not worth cracking open the statute just to do this, because I'm like you, I'm fearful of opening it up. But, even if we amended it to say, enrolled in and attending secondary school in the pursuit of a high school diploma, even if we just added a little bit of clarity, or enrolled in and attending high school or online courses in pursuit of a high school diploma, that would I think clarify it quite a bit.
Let me play devil's advocate for 1 second. I agree with you in 90, whatever, high 90%, but I think every now and then you get a child who is probably never going to secure a diploma or a degree, and yet they're enrolled in school for as long as they can be. And I'm talking about special needs folks, and we can't exclude them because they're not pursuing a diploma or GED.
Yeah, and I think that I think it is confusing secondary school because most people don't understand it, but I think it's also easily explainable. And certainly I know that a lot of percentage of our child support receiving and paying folks don't have attorneys, but those who have attorneys, explain to them, nope, secondary school means high school. In fact, I always put high school, or I put secondary parentheses high school. I made sure that they understood. And Christina, you probably do this in mediation. Secondary school is high school, because they start freaking out. I'm not paying for college, so you explain it to them, right?
Right.
And judges, we explain it to them when they say, well, it says he's got to pay child support till college, no, but times they are changing, and they have continued to change. I've seen it really change over the last 10 years, and even more so since COVID. More and more folks homeschool. And I don't mean to homeschool in quotes like there are not legitimate homeschool programs, because there are plenty, but there are some that aren't so legitimate. And when they get to be 17 and 18 and they're like, oh, he's still in homeschool, I'm like, yeah, right. Well, this seems like you're trying to get child support to age 20. So I do want to see, as a judge, I want to see some grades. I want to see that you're in there full time. I want to see, when is your anticipated graduation date? I mean, I want to see a little more than just, oh yeah, he's in school. I can't tell you how many young people are not regularly attending school anymore because we are so lax on this educational homeschooling stuff, and it breaks my heart because, this murder trial I was in last week, these kids were allegedly being homeschooled. Well, these kids, they never attended school a day in their life, and they're just traveling around the country in this RV. And, so I do think that judges need to be more stern on, asking, show me some proof of this enrollment and what's going on, especially for some of these older kids that have really dropped out of school, but they're still pretending to be in school, homeschooled. But I don't know what the solution is for the commission in terms of what we need to recommend right now for changes. I do think it's a good topic for us to be thinking about and putting some more thought into. Not only do we redefine secondary school as something more layman's terms, but is it, and I wish I had a child support addendum in front of me. Let me see if I do, because somebody just sent me something to sign off on. Yeah, here's one. So our child support addendum, where it came from, I don't know, but the one we use in the Macon Judicial Circuit has duration of child support, number 5, and then you put an X by one of the boxes, all right? The first one is beyond age 18 for high school. It says, the child support shall continue monthly thereafter until each child reaches the age of 18, dies, marries, or otherwise becomes emancipated, provided that if a child becomes 18 years old while enrolled in and attending secondary school on a full-time basis, then the child support shall continue for the child until the child has graduated from secondary school or reaches 20 years of age, whichever occurs first. So it does say full-time basis. And that's what I'm used to seeing in the addendums and in the settlement agreements that I see, is that they're enrolled in attending secondary school on a full-time basis. So, you know, if it just said high school instead of secondary school, I'd probably be okay. You know, I'd feel better about that language, but it does say full-time basis.
And there is a case, there's a Georgia case that goes into the question of full-time student or not, because, you know, I mean, in a traditional school year, you might have, most kids do have the summer off, but that doesn't mean you're not a full-time student. So there's a 2015 case, because I've had to cite it at some point, and yeah, and there's like language about the fact that you can still be considered a full-time student even when you're not attending during the summer. You know, you don't get to, a parent doesn't get to raise their hand and say, well, they're not full-time anymore because they hadn't been to school in the month. And you're like, which month? Well, June. So we do have some case law that defines full-time student.
Well,
And there was also case law back in 2011. I think this was drawn that did clarify that if a child's enrolled in online courses in an effort to graduate from secondary school, that it constitutes attending school. I don't think it brought up full time, but it did clarify it.
Yeah, no, it does. I'm looking at it now. Drawn, you're right, Kurt. Drawn versus drawn, and it talks about, you know, full time doesn't necessarily mean that you attend in person, but it does mean, you know, continuous and during the normal school year, and it goes into that language as well.
It kind of gives some definition of what full time is.
Mhm.
Yeah. Well, I don't think it's necessary to change the statute because of it, but in the future, if we're changing something, we might just remember to, hey, this is a good opportunity to throw high school in parentheses in this statute or something. So let's not forget about that.
To Kurt's
Sounds good.
point, I have a question about when he brought up about the pursuit of a GED certificate. So are we saying that the statute does include that, or it would not?
I would not
It
think
would
so.
not.
GED is
It
not
doesn't.
a high school diploma.
Okay.
Doesn't.
I mean, it's not. I mean,
Right.
so many young people think it is, but it's not. It's a GED. And a GED does not a high school diploma make. It's certainly better than no GED, but it's not a high school diploma. It does not mean that you attended and graduated from high school. All right, Katie, you want to take D?
Yes. Excuse me. Now I just swallowed wrong. So D is dental and vision insurance.
Want me to take D?
Yes, I really did just swallow wrong just then. So I would like to see us, again, I wouldn't, to use Kurt's phrase, I wouldn't open the statute for this purpose, but if we're doing something to it, I would like to see us acknowledge, in the health insurance language that can include dental and vision when it's available, so that it goes on Schedule D and the right prorations are applied to it. I mean, candidly, I would say most people do that anyway when they're doing it. But if you're following the letter of the statute really carefully and you go and you put it on Schedule E, the problem is, unless you're savvy enough to do the math and go ahead and prorate it, Schedule E deviations give dollar for dollar deviations. So if the dental and vision monthly premiums, total $50, and you put that in, then what you're effectively doing is switching the burden dollar for dollar from the parent who's paying it to the parent who's not paying it, by having it, increase or decrease child support. Whereas if it's on Schedule D in with health insurance, it's going to do the math internally so that it's switching the right amount between the prorations.
Pat, do you recall why that was not part of Schedule D to begin with? That's never made sense to me.
Yes, I do. Because health insurance is federally mandated and child support is federally mandated, and that's why it has its own schedule.
So I think the fact that our health
Because
insurance,
it's federally mandated means it couldn't be on Schedule D?
It means it has to be on Schedule D because it's federally mandated. It has to be part of the child support worksheet in a schedule where deviations are
optional.
optional. But Schedule D is Schedule D, and that's not optional. You just get that adjustment to your income based on the amount you're paying for the family health insurance, the children's health insurance.
I guess asking another way, you're saying health insurance had to be on there.
Correct.
But you're not saying that vision and dental could not be on there.
You might want to talk to Jane about that.
Okay.
And see whether, because it's in the language of the federal code, and vision and dental is not.
But yeah, let's talk to Jane about that, because that has always been so curious to me, because certainly if you have dental insurance, vision probably too, but dental particularly concerns me. If not, then, generally the parents are paying either the pro rata share or a 50-50 we see a lot of times of the uncovered medical expenses, which by definition almost always include dental, vision, counseling,
Orthodontia.
prescriptions, everything else. So it just makes sense to me that it's in there. And not on E. And like you said, when it's on E, you're trying to figure out, well, am I deviating the full amount or just partial amount, or am I, so I have always included it on Schedule D. I've just added it in, and I've thought, well, if the Child Support Commission is pulling my case to see if we did it right, mine's going to be one of the ones that's dinged, because technically the dental and the vision is not supposed to be on D. It's supposed to be on E. Noelle, is that something y'all would red flag?
I'm sorry, red flag it, that,
Like when you
like as an error?
when you pull it to grade us and say, this is how many were wrong, would you say,
Right.
you did this wrong because you included the dental and the vision on D instead of on E?
Right, yes, exactly. It is supposed to be on E, but I agree with you. I personally, and I think Katie too, like, I find it odd. I know it's not mandated, but I think it should be still on D. And then if it doesn't apply, if the parties don't have those insurances, then you just leave it blank. But if they do, then you account for it so it gets properly handled. Because I think when it goes to E, folks do weird things, and they don't, to Katie's point, apply pro rata shares to that expense. So
Yeah, they just say, all right, minus $50 or whatever it is. And it's a dollar for dollar deviation.
right.
Yeah.
Right.
Anybody else have any questions, comments, concerns, yays, nays regarding moving the dental and vision out of Schedule E where it's a deviation, move it to Schedule D where it would be treated like health insurance? Who thinks that's a good idea? Who thinks that's a bad idea? Good.
I think it's a good idea.
I think it's a good
People
idea,
do it
but I
anyway,
do
the most
think
part.
you should run it by Jane Venor.
Yeah. Yeah. Well, when we talk to Jane, let's put that on our list, Kurt, of things that we need to ask her. Is there any legal reason why we should not move that to Schedule D? I almost I'm almost inclined to say it would be worth opening up the can of worms. I mean, it's such a problem to me that that's on E. And, you know, but if we're going to talk about removing the 7% test, then, you know, we can handle both of those at the same time and maybe redefine secondary school.
Mhm.
All
Yeah.
right, Noelle, talk about military housing allotments quickly, if you will.
Yes, briefly, and this is some good news. So I was at a CLE event in Cobb that was specifically about military divorces. And one of the presenters, Patty Shoemaker, who practices in this area, thought that there could be some clarity added regarding the military housing allowances in the subsection of the statute that deals with income. But then we met with her one-on-one, and she no longer felt like there were any changes needed, which was a great relief. But we did work with her, and I thought I would just call your attention to this. Staff, and thank you, Kurt, for getting it up on the website. But we have some new information under our resources tab about military housing and military planning.
So this is just another thing that we can handle better with education than with statute changes.
Exactly, and we can take it off the agenda. Like, we followed up with her. She raised it and then she changed her mind, but we have added additional resources to the website just to be helpful to people dealing in this area.
Good.
Yeah.
Patty is a great resource. I used Patty a lot, handling when I had military, pension division orders, or when I had, military divorces where I needed an expert. All right, so.
I have a quick clarifier on where we stand about opening up the statute this legislative session or not. Like, the only thing we have pending was what you left with Katie, right? Whether she felt that language needed to be added about modifications. Is that where we stand?
Well, we were going to talk to Jane and see if we could get any answers to some of these other questions before the legislative session. I don't know if that's going to be doable, but we wanted to get some feedback from Jane regarding the 7% test and the dental and vision insurance, as I understand it.
Yeah, okay, for sure. I know, and yes, all of those topics that we said kick over to Jane. I just don't know if we're going to be able to like fully flesh all of that out before, you know.
I doubt it. I doubt it, but I mean,
Okay.
that would be ideal, but probably not going to happen because we're in December right now.
Right.
All right. And so anything else, Katie?
I think that was it on that. I am opening the floor to any new business. And I am going to put one thing on our radar. We do not have to discuss it today, but I want to put on everybody's radar that the guidelines in their current iteration, when you look to, when you have an issue of contempt related to child support for parents who were never married, there is not a clear statute in our code under which the parent who pursued contempt against the non-paying parent can seek attorney's fees for having to bring that suit. And I know I'm preaching to the choir that everyone in this meeting knows that we have an ongoing issue with our legitimation issues in general. But I would say that where you have never married parents dealing with enforcement of child support, and there is not a clear statute under which they can get attorney's fees for having to pursue that through the court system, we are, you know, treating the children of never married parents versus the children of at one point married parents differently, simply because of one having been married at one point and the others never having been married. So I think it's something we could consider. Again, I'm not suggesting we do it today, or even this next legislative session, but I do think it is a hole in our code that we don't have a way for them to seek attorney's fees for an enforcement of a child support order.
And would that be part of the commission's work?
Well, I guess that's a great question. I mean, we certainly have language in our current statute about attorney's fees for modifications. We don't have any related to enforcement. You know, I don't know. Maybe I need to go read our charter and our instructive language, but I am talking about the narrow situation where you have enforcement of a child support order, and no remedy for child support for the parent that has to bring it. I don't know. So it's a good question though, Judge Williford, and I don't know the answer. Maybe it's outside of our purview.
Tracy Palma says the same should be added for the custodial parent not giving the non-custodial parenting time. That's also not child support commission work. All right, so is there any other new business that we need to discuss?
None from me.
All right, well, what we'll do for our next meeting is come up with some dates that we will discuss with and I say we, being the co-chairs, Katie and I will come up with some dates that we will discuss with the staff, and then we'll put out a survey and see which ones are more likely to reach quorum before we schedule it. So I do appreciate that y'all were all here today, and that we were able to move through all of the topics on our agenda. We didn't get a lot of real answers, but at least we got questions, which is important. Noelle?
I just want to clarify, so those dates will get, your dates will also get dates from Dr. Venor, because our next meeting will include her.
Okay.
Is that how you see it?
I think we should get our dates and then talk to Dr. Venor, because,
Yes.
we need to be available even if, so see of our dates, which ones Dr. Venor can do, and then let's get it all out there.
Yes, exactly. Get your dates, and then we'll loop in Dr. So there's nothing else you want staff to do at this moment other than coordinate with you and then Dr. Venor about our next meeting date. Is that right? I just want to make
Correct.
sure.
Correct.
Okay.
You agree, Katie?
I do. Yes.
All
Thank
right.
you.
Well, I hope y'all all had a happy Thanksgiving. I appreciate y'all being here today. We're going to be able to finish about 15 minutes early, which is surprising to me. But it is now 4:45 and the meeting is adjourned.
Bye, everybody.
Bye.